Anyway, I'm Juliet Kapritsky. I'm director of the Center for Business Law at Case Western University School of Law. As many of you might already know, the center sponsors several business-oriented events a year at the law school. I am delighted to introduce the first event of the 2021 academic year on real estate, private equity, joint ventures, key terms. Our next event is the LEAT Symposium on November 6th on the concentration of equity holdings in the 3 largest index funds. Professor Ed Rock from NYU will be the keynote speaker. But today, our speaker is Dominic DiPuccio from the Taft law firm. And we're absolutely thrilled that Dominic is here to share his expertise. So he is chair of Taft's Mergers and Acquisitions Group. He focuses his practice on mergers and acquisitions, public and private equity, and debt securities offerings and joint ventures. He represents entrepreneurs, emerging growth and seasoned companies, public and private, investors, venture capital and private equity funds, and real estate sponsors in a wide variety of corporate finance and joint venture transactions. So the Taft law firm is very fortunate to have Dominic, and we are very lucky to have him talking and sharing his expertise today. Dominic counsels buyers and sellers on all aspects of mergers and acquisitions and capital raises, including due diligence, letters of intent, deal structures, pricing alternatives, negotiations, documentation, and closings. And he also represents public companies and public offerings and the SEC registration process. So with that, I'm going to turn it over to Dominic, and he will take over the screen. He will talk to you, but I will monitor your questions, and there will be time for questions. And I think I should clarify whether Dominic DiPuccio wants to be interrupted at all or whether we should proceed to the end.
I'm happy to be interrupted if the timing's right. I don't think I can talk for an hour straight.
Okay, fine. And I'll monitor questions as they come up.
Great, great.
Terrific. I turn it over to you now.
Well, thank you, Professor. As I'm going to walk away from the screen so I can share my screen, and then I'll come back. My PowerPoint. It's nice to see everybody, even though I can't actually see anybody. I'm talking to a wall. So indulge me. This is a little bit of a strange format. I'm happy to be here, and I'm happy to see you, Professor. It's been a long time since I was your summer research assistant back in, I think, 1988, if anybody remembers that year. I barely do. It was a long time ago. I guess that's why my bio is so long. I've been doing this for a long time. I appreciate the opportunity. I want to talk about just a couple things up front. First, I am going to be talking about real estate joint ventures with private equity funds, and a couple high-level comments to start us out. First of all, I'm mostly going to be talking about these terms and these issues from a sponsor's point of view, and I'm going to use a lot of words interchangeably. I may say sponsor, I may say operating member, I may say manager. In all cases, I mean the real estate expert that is joint venturing with the private equity fund. On the private equity fund side, you may hear me say fund member, fund manager, or just fund participant. This is intended to be a high-level review. It's an hour. There's a lot, as you can imagine, there's a lot of things to talk about. So I have to keep it at a high level, and I'm not familiar with the audience, so I don't know. This may be very rudimentary to some of you. It may be over your heads for others. I'm trying to sort of play that balance somewhere in between. I do encourage questions. I can talk for a long time, but I'd much rather have an engaging conversation with people if that's possible. I'm mostly going to be focusing on U.S.-based joint ventures. Clearly, there are foreign real estate joint ventures that go on. They're very similar in a lot of respects, but they also have their own wrinkles. And this format and this time allotment is just not going to, that's not going to be able to happen. I'm not going to get into tax considerations, tax aspects. I'm not going to get into specific kind of nuanced structures, whether they involve sort of tax-exempt financings or participants, whether they involve foreign investors, whether they are special funds like Sharia compliant funds. Believe it or not, we have a great deal of experience doing joint ventures with funds that are Sharia compliant, and they have their own sort of complexities. I'm not going to get into an analysis with REITs. I'm not going to get into pension funds and ERISA kind of issues. And I'm not going to get into sort of tax credit deals, whether they be historic tax credits or conservation or preservation easements kind of deals. So that's what I'm not going to talk about. I'm also not going to get into the nitty gritty of the dirt. The cool thing about these deals, I think, is it really requires three fundamental subject matter experts. You need someone on the deal side that understands the joint venture. You need someone on the real estate side that knows how to buy real estate, how to mortgage real estate, how to lease real estate, and that is not me. And you need somebody on the financing side that knows how to do and negotiate, senior loan agreements or mezzanine loan agreements. And when you get to, the big firm level, as many of you I'm sure know, these are all sort of specialties. So we pull in our team and we all work and we all collaborate together. But I'm not going to get into the real estate aspects, and I'm going to just barely touch on the financing aspects. And last, I just remind everybody, like I remind all my clients, there's no such thing as a perfect contract. A contract is only as good as the parties that are signing it. At some level, there has to be some trust, and there has to be some sort of personal bond where you know that the party on the other side is not going to just stick to the letter of the law, the word of the agreement, but there's going to be some good faith, or more importantly, a lack of bad faith. So with that oversight, let's get started. So what is a joint venture? Well, very simply, let me do the overview first. I'm going to talk about two things. What is a joint venture? We're going to get into a little bit of a conversation about real estate private equity funds. We're going to talk about the benefits for both fund participants and operators. We're going to talk about the risks for both groups. And we're going to do a little bit of a comparison with sort of traditional private real estate syndications that many of us are very familiar with and probably cut our teeth doing. And then the next big piece is, the more important piece, probably the substantive piece, is we're going to get into the major deal terms. We're going to talk about the initial considerations that kind of shape the overall terms and conditions of the deal. We're going to talk about structure. We're going to talk about economics. We're going to talk about management and control. We're going to talk about peculiar issues like non-competes and rights of first offer. We're going to talk about the restrictions on transferability. We're going to talk about buy-sell matters, and we're going to talk a little bit about the intertwining of these joint ventures with the loans and how they are, even more than normal, how they really are intricate and intertwined with each other. So, all right, so what is a joint venture? So we know what a joint venture is. I mean, traditionally, a joint venture is two parties contributing something to one joint enterprise, co-owned enterprise. Often it doesn't have to be a co-owned enterprise. In this context, it always is, in my experience, a co-owned enterprise. You're matching highly experienced real estate operators with professional capital. So you get operators who are going to contribute their time and effort in exchange for hopefully a disproportionate return to the capital that they're invested. And that disproportionate return is what motivates them to generate higher returns for their fund partners. It's interesting to note that like many transactions, be they real estate or traditional corporate, but particularly in real estate, there's often a capital stack, what we call a capital stack. It starts with the senior loan on top. There'll be some sub debt, maybe some mezz debt. You might have some community loans or grants like Cleveland Development Authority kind of things. Then you're going to have your maybe private equity, preferred equity, maybe common equity partners, and you may even have, just to make things complicated, a historic tax credit investor. So somewhere in that stack is where this joint venture is going to fit. And again, it's not only important to remember how to structure, how to negotiate, how to document these joint ventures, but it all has to fit in the puzzle of the capital stack. It's important to remember. Traditional private equity structures, it's not much different than a corporate private equity transaction. Instead of matching money with real estate experts, we're matching, in those contexts, you match money, and a traditional corporate private equity firm will have you know, a slew or a stable of managers and executives that they put into their deals to run the deals. It's important to remember that when looking for a potential partner, again, from the sponsor's point of view, you want to find a fund that matches what it is you're doing. And what does that mean? Well, every fund has its own sort of investment thesis, right? So you want to be talking to funds whose investment thesis matches whatever your project might be. And that means that it has to match an asset class. So you might have funds that are interested in retail deals, office deals, industrial, hospitality, schools, multifamily. So your deal needs to match with whatever the fund is. There's also different types of funds even within each asset class. You've got core funds, core plus, value add, opportunity, and sort of the distressed debt and mezzanine debt kind of funds. And those are in order of sort of risk profile. A core fund is a fund that really only invests in fully stabilized, low leveraged projects. And on the opposite end of the spectrum is a distressed fund that is interested in investing in distressed and troubled situations. And obviously we all know that there's a balance between risk and reward. So a core fund might shoot for 6 to 8% returns, and a distressed fund might shoot for 25 to 30% returns, because some are going to be misses. So it's important to match your deal with the right fund. On the risk reward side, it's important to remember these sort of general big picture factors that affect how funds and investors look at real estate deals. So what is the leverage amount of the deal? We all know that the beauty of real estate is that almost unlike any other industry, you can borrow so much purchase price relative as a percentage of total purchase price. You can really lever a real estate deal. So the more leverage, the riskier the deal. And that's the way your funds are going to look at it. Are your investors looking for current returns, or are they playing just for the back end appreciation? Are you in primary markets, New York, LA, Chicago? Are you in secondary markets, you know, Beechwood and suburbs of Cincinnati, for example? And what's the hold period? How long do investors anticipate staying in the deal? And what's the exit plan? So let's talk about why do sponsors and operators like joint ventures? Well, most of this is obvious, but let's walk through it. You can do more deals with less equity. Without a joint venture partner, if you had $1 million, you could probably do one $7 million deal. But if you had a joint venture partner that was willing to put in 90% of the capital, well, then by definition, you would be able to do 7 deals with that same $1 million. So you can do more deals with less equity. That also means that there's less risk per deal. In highly competitive situations, fully marketed properties, especially clearly not now in this COVID world that we're in, but before COVID, when properties were trading at super high multiples, or said in the real estate world, super low cap rates, there's intense competition for deals. And if you have a private equity partner, you can move a lot faster. That makes you more attractive to buyers. It gives you access to bigger and more complex deals. And it gives you access to the professionals that are resident in the fund. You've got analysts and underwriters that they're Harvard grads, they're whatever they are, they're super smart sort of MBA types that's all they do is digest this information. With a private equity fund as a partner, you've got greater access to lenders. You've also got a reliable go-to equity source. Once you do one good deal, they're going to remember you, and it's going to be a lot easier the next time to do another deal. It also gives you an opportunity to expand your geographical scope. It gives you an opportunity to expand into different asset classes. Equity is clearly preferable to mezzanine or sub-debt, depending on how you look at it, but generally speaking, you'd rather have an equity partner than pile on more debt to the deal if you can avoid it. And as a sponsor, you get disproportionate returns. That's the whole point. You can put 10% of the money in, but you might end up with 40% of the deal as a result of the promotes or the carried interest, which we're going to talk about a little bit more. And there's an opportunity just because you can spread out your overhead among more deals, so you have an opportunity to sort of cover some of your overhead with fees. On the private equity side, why do they like joint ventures? Well, again, it's kind of obvious. So they get access to really sophisticated and experienced operators. They get an opportunity to diversify their operations and diversify their risk. They get a reliable stream of operators. They take some risk out of the deal. Usually private equity groups are not on the non-recourse carve-outs. They're not on the guarantees, whether they be payment guarantees or performance guarantees or environmental indemnity type things. So they avoid those risks, and they get preferential returns. So they're protected on the downside. If a deal goes south, their money's going to come out first. They get enhanced and diversified deal flow, and they get major controls without day-to-day responsibilities and headaches. And they have some competitive advantages because the way these deals are structured, as you make partners, joint venture partners, you start putting footholds in the country, and you start creating these areas where other people may not be able to compete as well as you can. So you get a little bit of a competitive advantage. What are the risks to the operators? Well, pretty obvious. You don't have unfettered control that you're used to control your deal. Somebody's looking over your shoulder, and somebody needs to approve important decisions that you're making. You have the risk of being removed for whatever reason. You basically have a risk of getting kicked out of the deal, and the consequences, which are not good if that happens. You will likely have to agree to a non-compete in a certain geographical area, and you will likely have to agree to provide your private equity partner with opportunities to participate in new deals. And there's also disproportionate risk. So much like there's disproportionate reward, there's also disproportionate risk, because you're the guy on the guarantee, you're the guy in trouble if there's an environmental problem, not your partner. So you're in for 10% of the equity, but you're in for 100% of those kinds of risks. Fund members, again, pretty obvious. You don't have day-to-day control, so you're relying on the operators to do the right thing and pay attention to the properties. Obviously, it goes without saying that your operator partner, this is not his only deal. He likely has a portfolio of properties across the country that he's got to pay attention to. So you've got the risk of your operating partner having distractions. And sometimes you have conflicting interests. So imagine your joint venture partner is approached by Amazon, and Amazon is looking for 200,000 square feet, and your operating partner says, well, I can put him in the JV, or I could put him in another building that I own down the street. So you potentially have conflicting interests. For those of us who cut our teeth on traditional real estate syndications, let's just talk about sort of the differences real quick. Many of us, like me, old school, we still think in terms of general partner, limited partner kind of structures. We often still use that phraseology. We will call investors LPs, even though they're not limited partners. They're often members in an operating agreement. But in the traditional structure, they were not usually negotiated at all. You presented your pitch book or your private placement memorandum with your term sheet or your partnership agreement, whatever it is, and it was take it or leave it. Nobody was negotiating it. The limited partners did not have a lot of say in the deal, and they really had very little management rights. They had very little remedy if there was mismanagement. The splits were much simpler. Oftentimes the preferred returns were sort of accumulated preferred returns as compared to compounded internal rates of return, which are completely different concepts. There was a much greater opportunity for the operator to sneak in fees in the deal because your investors weren't really aware of what they could or couldn't push back on those. And there often wasn't any clawbacks, which we'll talk about a little bit later. Before we move to any deal terms, any questions?
Yes, we have a question right here from Jeffrey Wiedenthal. I don't know if it's a good time, but he says, are there any consistent lessons from deals that have gone bad in a good economy? Are there lessons to draw from that?
Well, we're going to talk a little bit later as we talk about deal terms, what the risks to the operators are, because the downside risk is the operator risk. And funds are motivated differently than operators. Their time horizons are different. Their investor base is different. And for example, in some of these deals, we're going to talk about the fund might have the right to cause a property to be sold at a particular point in time. And that may be because they just, they're at the end of their fund life. They need to return their money to their investors. They're trying to get their numbers as good as they can. And you might be thinking, well, I want to hold on to the property for 3 more years. And so you've got those conflicts of interest, even in good times. So, and as you can imagine, you've got seasoned real estate folks on the one hand, you've got professional money managers on the other hand. There's always going to be butting of heads. There's always going to be egos. Even in good times, it's not always going to be smooth. The real estate operators are not used to the minutia, the reporting, the phone calls, the meetings, the process. They just like to make decisions. The professionals, they don't operate that way. Everything they do is organized, outlined, planned in advance, reported afterwards. So you've got a difference of personalities that can lead to some tension, even in good times.
Thank you.
And I think the lesson from all of that, to answer the question, is you got to find a partner with a good personality match, with a good investment kind of match, where you're both sort of looking for the same things, because it makes a big difference when you get along with your partner, not unlike every other situation in life where you're talking about a partner. As we get into the major terms, there are a couple big picture things that shape the terms and conditions. Relative capital contributions of the parties, the risk reward profile of the project, and the operator track record. So if the operator's putting in more money, if they've got a 10-year track record of a whole bunch of successful deals, if the project isn't all that risky, you're gonna get better deal terms. To the contrary, you're not. Structure, these days we're, more often than not, we're Delaware LLCs or limited partnerships, but more often than not, we're LLCs. LLCs are give you the greatest flexibility. They give you all the good stuff with partnerships and all the good stuff with corporations kind of mixed together. They're creatures of contract, which means they're limited only by your own imagination in terms of terms. More often than not, the property will be held by a special purpose entity, a single purpose entity that will be the borrower as a wholly owned subsidiary. And if you've done any of these deals, particularly with some of these special types of funds, the structure on their side is dozens of entities and dozens of arrows and all kinds of stuff that doesn't really affect the sponsor, but is fairly complicated stuff. More often than not, the sharing percentages in these JVs is either 90-10 or 95-5. In a deal that has a little bit more risk, you might see like 70-30. But usually the operator's putting in 5 or 10% of the capital. The fund is putting in 95% of the capital. So you can see that disparity between who's putting in what. At the end of the day, the fund just wants to know that if you lose, it's going to hurt. They want to know that you have skin in the game. It doesn't bother them one bit that they may have 9 times as much money in the deal as you, or maybe 20 times. What type of deal is it? as far as, so that was about the initial capital. What about additional capital? And a lot of questions come up when it comes to additional capital contributions. And these are oftentimes foreseeable depending on the type of project. If it's a stable property, additional capital may not be all that foreseeable, may not be all that heavily negotiated of a point, because you really just don't see the need for additional capital. You're making money, it's making money now. You can set some money aside for reserves, so you don't have to worry about additional capital. Is it a value add where somebody's going to go in, they're going to repaint the whole thing, they're going to change the walls, they're going to swap out appliances, they're going to add swimming pools and basketball courts, and then they're going to flip it in 5 years after putting in a whole bunch of money? Well, that obviously that is very foreseeable that you may need more money. With new development, same thing with new development or construction, everybody's got a budget, but everybody knows that there's no such thing as a budget that is not ultimately overrun. So who's responsible for putting in those money? Oftentimes in these deals, there's a little bit of tension because the sponsor may want more money, but usually you have to get the private equity fund to approve a capital call. Or conversely, and even more troubling for a sponsor, in a lot of deals, the private equity fund is allowed to just make the call themselves. So you try to limit it to what conditions, because you don't want to be told that you have to put in more money. So in some cases, the fund might have sole discretion to make a call. In some cases, you might get them to agree it has to be good faith. They have to deem it necessary to maintain operations, pay liabilities, avoid property damage. Sometimes you can limit it to emergencies only to avoid personal injury or material property damage. And sometimes you're just talking about construction budget overruns. Oftentimes, one of the things you deal with in these deals is, well, what happens if there's a capital call and one party doesn't buck up, which we all know means the sponsor, because the fund member is never going to make a call with no intention of actually bucking up. And so what happens? And the remedies are usually one of these three or some combination of these three things. The fund member can make a loan on behalf of the operator and treat that as a priority loan that gets paid back first before any other distributions. There might be dilution, which may be with or without a penalty for not bucking up. And it may even be a default, and it may constitute a removal event. Let's talk about waterfalls. This is the juice of the deal, the economics. Who gets what when? The typical waterfall it can be a single level IRR return benchmark, or it could be multiple level IRR benchmark. But generally speaking, when there is free cash flow to distribute, it'll first go to pay any member loans, if there are any. Then it'll go to pay both partners in proportion to their percentage interest, so in this case, maybe 95.5, until there's an IRR threshold that's met. Once that initial IRR threshold is met, there's going to be a promote that kicks in to the sponsor, and then pro rata after that, and sometimes there may even be multiple promotes. This would be an example of a typical waterfall. First, to pay any default loans. Next, to both members pro rata until they achieve a 10% IRR. Then 20% to the operating member, that's the carry or the promote, and then pro rata with the remaining 80% until there's 15% IRR or a 1.65x multiple on capital. I'll talk about that in a second. And that goes until they reach that 15% IRR, and then it kicks in, the promote goes to 30%. So you can see in this deal, this example, the beauty of the promote. The investor only put in 5% of the money, but all is going well. Now they're getting 30% of the returns. And that's why they're in these deals, those disproportionate rewards. It's important to remember the equity multiple concept because inherent in the calculation and determination of IRR is the concept of time. So you could get a guy, a fund member partner, an IRR that they want in 2 months, but they're not in the deal to make 50 grand on their 1 million. They want to make 2 million on their 1 million. So there's often this two-pronged concept of both an IRR and a multiple, because they want to be in the deal long enough to make it worthwhile. Getting a 10% return after 6 months is no fun. It's not, the juice isn't worth the squeeze for these deals. So they'll often add that kind of a concept. It's important to remember that in a lot of these deals, there's an obligation to kick back some of your promote. If at the end of the deal, the IRR, minimum IRR was not reached, and you might be wondering, well, how could it be that I was able to get money from my promote, but I didn't ultimately hit the IRR threat? And this usually happens in one of two ways. A deal starts out good, and then it goes bad. So everybody's making money, everybody's getting distributions, the promote's kicking in, and then the deal goes south, and you go a couple of years without distributions, or maybe you're even putting in money. Or you have a deal where there's multiple projects, a couple good properties, a couple bad ones. You're getting paid on the good ones and the bad ones kick in. There's a couple different ways this can happen, but it's something to be mindful of and it's something to be careful of. Let's talk a little bit about fees. There's always an opportunity to get fees in these deals on both sides, sponsors and operators and private equity funds. Acquisition fees, financing, refinancing, debt placement fees, asset management fees, property management fees, leasing fees, development construction fees, or disposition fees. And in many deals, these fees are often also subject to a clawback if minimum returns aren't met. So your fund manager might say, hey, you've been taking all these fees out of the deal. I'm not getting my expected return. You need to put those fees back in the deal. So you need to be careful of that. So after economics, the other big thing is management and control. So obviously the fund partnered with an experienced real estate operator because they know how to operate this type of real estate. But it's not unfettered discretion on the part of the operator to do whatever he wants. There's a lot of oversight. They're generally permitted to do effect day-to-day decisions within approved budgets and business plans. But the fund member makes decisions, always makes decisions regarding any contract or transaction that involves the operating member. So for example, usually the operating member or an affiliate is the property manager, and it would be the fund member then who has the right to enforce that property management agreement or terminate it, frankly. And it's important to be mindful as an operator of what your member duties and your standard of care is, because remember, we are in state law, LLC law, there's fiduciary duties, your partners, there's contracts, but there are still obligations of due care and due loyalty that are often embedded in the verbiage of these deals so that everybody understands what their obligations are to each other. There always is a concept of major decisions. So within the day-to-day management that the operators have the right to do, there's also usually a big list of things that they cannot do without the fund member's approval. And in a lot of cases, the fund member, not only do you need the fund member's approval to do these things, but the fund member can actually cause the company to do any of these things, whether you want to or not. This would be a sample list of those types of major decisions: selling the project, financing the project, what type, believe it or not, what type of accounting you're going to use, and what are your accounting principles, spending money outside of budgets, hiring third-party service providers, whether they be accountants, lawyers, environmental consultants, brokers, etc. They generally are in charge of decisions regarding additional capital. They control taking legal actions. You might be able to carve out, and we often try to carve out, we're successful with at least giving the operator the freedom to sue tenants who are in breach of their leases. You shouldn't have to go to the fund member to say, I need to sue a tenant, or I need to bring a legal action against a tenant. Things like bankruptcy, distributions are always in the purview of the fund manager or the fund member, changing organizational docs, leases, and sometimes there's a bifurcation between what they might call a major lease and what might be a minor lease. Those are also generally decisions that the fund member is going to want to control. And most importantly, operating budgets and business plans, which are super important because the operating budgets and the business plans sort of set the parameters for the operating manager's freedom within which to operate. So if it's within the budget, if it's within the business plan, the operating member can do anything that's consistent with that. Outside of that, you're going to need the funding member's approval. And as you can imagine, there's conflicts of interest. There's times when the operator may want to spend money and the fund member doesn't. The operator says, hey, I'm the expert. I know what this property needs. We need a new roof. The fund member says, we're not putting a new roof for another 3 years, for example, things like that.
Dominic,
you look like you have a question. Go ahead.
Yes, a question has just come up and it pertains to something you just mentioned. So I will raise Basil Boyle's question. How do you handle potential conflicts of interest between the operator and the created entities with respect to another participant, such as someone contributing land or money?
I'm not sure I understand the question. Do you understand it, Professor?
Well, the potential, what do you see as potential conflicts of interest?
Well, we're gonna get into a couple things in a minute, but
okay.
For example, the example that I gave, you're an operator, you have 50 properties across the country. Maybe you're in the industrial space. You've got a bunch of distribution centers. You have one property with a joint venture private equity partner. A tenant comes along, a hot tenant. They want 200,000 square feet. Where are you gonna put him? Of course, your joint venture partner wants you to put him in that deal because that's good for him. You may, for a whole burst of other reasons, think it's better in another property. You might have another property that's hurting, that really needs a tenant. And so you always have those kinds of conflicts. But we're also going to talk about a little bit about sort of non-competition. Operators are generally prohibited from competing with these projects within a certain radius. And there's also a broader radius within which, if there is an opportunity, the operator is obligated to bring it to the fund manager, the fund member, to see if they want to participate in that deal. And that gets, we'll talk about that in a little bit. Budgets are really important, and they need to be done annually. Generally speaking, operating members are obligated sometime in early winter or late fall to deliver a draft of a budget. And the fund member is going to have the opportunity to approve it or not. And you need to think about and build in, well, what happens if you can't agree to a budget? And normally the answer to that is you default to the prior year's budget. And then the question becomes, well, what about fixed expenses that are greater this year? What about my insurance is more, my taxes are more? Clearly you want us paying those. So it might be, we're going to go back to last year's budget, and with respect to any fixed expenses, taxes, insurance, utilities, for example, if they go up, you can pay those. But discretionary expenses, the answer is usually no, you're sticking to last year's budget. Or you'll sometimes see like a CPI index built in. If the CPI index of inflation index is 1.5%, you can get a 1.5% bump on discretionary expenses. All right, the bad news. For all the reward that the operating member has, there's also a lot of risk. There's a lot of ways that a fund member can just say, you know what, you're out. And you don't want that conversation. So you try to, as a lawyer representing the operator, you want to limit and restrict the ways and the types of events that can give rise to being removed. And they're generally referred to as removal events, no surprise there. Sometimes it relates to the operating principles, right? So if the operator is dependent on one or two people that are key, you may say if those guys leave, or if they die, God forbid, or they get disabled or they get sick, then I can kick you out of the deal. Or obvious things would be like if you misuse funds, if you commit fraud. Obviously, these are legal words, but they're important. What's the standard? Is it misrepresentation? Is it gross negligence? Is it willful misconduct? Is it just ordinary negligence? I mean, obviously, you want to be very concerned about these things. What if you don't pay your insurance or your taxes? Well, you're going to get kicked out of the deal. Well, what if you don't have the money? You try to build in an exception. You can't kick me out of the deal for not paying my insurance if the money's not there. You can kick me out if the money's there and I don't pay it, but if the money's not there, that can't be my problem. Causing damage or destruction to the property, breaches of reps or warranties. So like every deal, reps and warranties have a very heightened sense of importance in these deals. What if you breach the JV agreement, try to limit it to some element of materiality and get some opportunity to cure it after notice? If you fail to make additional capital contributions. What if you default? What if there's a loan agreement default? Is that something you can blame the operator on? Well, maybe, maybe not. So you try to limit that to a default that's actually caused by something the operator did or didn't do. You can't kick the operator out if the project fails and it's not producing enough revenues to pay the debt service. That can't be a reason. Sometimes it is. Just as important, something we try to fight real hard against, but some funds are pretty obstinate about this, is if you don't meet budget or you're off by more than 10%, we can kick you out of the deal. May not even have anything to do with the fault of the operator, but these kinds of performance standards are often used as a reason to be able to kick a guy out of a deal. Let's say you're on deal 7 with your favorite private equity fund. There's often going to be what I'll call like a cross default. If you get kicked out of one deal, you're getting kicked out of all the deals, even though whatever you did or didn't do only related to one deal. So you got to be very careful with things like that. And why do we care about being removed? Well, first of all, there's going to be a new guy in charge. So now your investment is no longer within your own control, it's within somebody else's control. You'll likely lose your promote. So if you're in for 5% of the deal, forget your promote, you're only in for 5% of the deal. They can terminate any contracts they have with your affiliates, like your property management agreement. And it may trigger the buy-sell right. It may trigger a right to get bought out either at sort of fair market value or at some penalty, depending on why you got removed. There's often a concept called bad boy events. And if you commit one of these bad boy events, you can get kicked out of the deal. You can get removed as manager. You can get bought out for maybe just getting your money back. That's it. Talked a little bit about this earlier. Another piece of these transactions, there's usually a concept of a non-compete and a concept of a right of first offer or right of first refusal. Within a small radius, maybe like 10 miles, it may say you, as the operating manager, you cannot, under any circumstances, participate in a project within 10 miles of this project without our consent, period. Beyond that 10-mile radius, it may say beyond 10 miles, but within 30 miles, if you do a project within that geography, you have to give the fund manager, the member, an opportunity to participate. And as they all know with rights of first offer or rights of first refusal, they sound inherently fair, but they can often be problematic. You're trying to get a deal done. You're trying to convince a seller to sell their property to you, and you're wasting time with your partner trying to figure out whether he's in or not. So you want to put very tight time frames, very tight protocols, very tight mechanics around how that gets exercised, when it gets exercised. And frankly, it's a one-sided coin. The fund member does not have any of these kinds of restraints. They can generally compete with you whenever they want. Another big issue is transferability. Generally speaking, operating members are often significantly restricted in their ability to transfer their units to a third party. You can usually negotiate the ability to make transfers for sort of estate planning purposes, internal reasons, so long as it's not tantamount to a change in control. And on the other hand, the fund member, obviously being a fund, they need the right to get in and get out. They need the right to transfer their units if they want. They need the right to for their investors to transfer their interest in the fund without triggering these types of restrictions. So it's not a two-sided coin with respect to transferability. Second to last thing we're going to talk about sort of buy, sell, and special purchase rights. So in some of these deals, there is some kind of a time horizon. After that time horizon, whether it be 24 months or 36 months or 48 months, the fund member might have the right to force a sale, or they might have a right to trigger a buy-sell event where they buy you out or you buy them out. It may be after a period of time. It may be triggered by a removal event, and it may be forfeitable. Oftentimes, one of the other bad consequences of being removed as manager is you lose your right to exercise a buy-sell. And what types of buy-sell arrangements are commonly used? A forced sale of the property, which if used, you want to make sure that it's fully marketed. You want to agree up front to certain terms and conditions, what kind of reps and warranties you're going to agree to, et cetera. It might be based on an appraisal where the fund member can buy out the operating member based on an appraised value. It may be what I call a shotgun, but that word is used differently by different people. They sound inherently fair, but they're, I'll explain why they're not always fair. But a shotgun is simply, if somebody exercises a shotgun, they throw out a number. I think the property is worth $100 million. Your job then, as the recipient of that, on the other side of that offer, is your job is to decide whether you're going to buy his interest for that price or sell your interest based on that value. So the funding member exercises his buy-sell right. He throws out a property value of $100 million. Somebody does the math and says, if we sell for $100 million, this is how much you get, and this is how much you get. And the other party then has a right to say whether he's a buyer or a seller. Sounds fair because it forces the guy making the offer to throw out a fair price. It's not always fair because it becomes a battle of wallets. And while it may be a fair price, he may know, your partner may know that you don't have a lot of money, and that means you're most likely to be a seller and not a buyer. And by the way, if it's you, if you're the sponsor, you're buying 90 or 95% of the deal. If it's the fund member, he's buying 5 or 10% of the deal. So his check is a lot smaller than your check. So he might lowball the price knowing that you're likely going to be a seller. And then as I mentioned earlier, the price may be reduced almost as a penalty. We don't use those words because they're generally illegal in contracts, but it's going to be a reduced price if a bad boy event occurs. Lastly, the interplay with these JVs and loans. As you can imagine, things like guarantees. As we mentioned earlier, it's usually the operating member that's on the hook for the guarantees, not the fund member. So we know what's obvious about that risk, but maybe one that's not so obvious is, well, what happens if you get kicked out of the deal? Well, you're still on the guarantee. So now you have no control over the investment, and you have no control over things that might trigger a non-recourse carve-out guarantee or a environmental indemnity. The new manager may have no skin in the game on the indemnity. He might be pouring solvents all over the place. What does he care? It's your nickel, not his. So you try to build into the loan agreements something that if you get kicked out of the deal, either a replacement guarantor will be approved, maybe pre-approved, and it probably triggers a default. So it's another reason why these deals get really tricky, because even from the fund member side, they don't want to trigger a default by kicking you out of the deal. So they say to the lender, hey, I need the right to kick this guy out of the deal, even though your loan agreement says if he's no longer the manager, it's a default. So you've got to negotiate those things up front. Types of guarantees, we talked about payment and performance guarantees, environmental indemnities, non-recourse carve-out guarantees. I think anybody who practices in this space knows what all of those things mean. So I find these deals really interesting. They're complicated, requires some real creativity sometimes, negotiating skills. You're balancing a lot of competing interests. You've got lenders with their interests. You've got partners with their interests. You've got tenants with their interests. So buyers and sellers of the property. It requires a lot of collaboration with different subject matter experts on the legal side and on the accounting side. And I find these deals really interesting, and I enjoy doing them. And I'm happy to answer any questions that we have.
That's fantastic. Thank you so much. So now it's time for questions, and I think I see one in the chat. What are your thoughts from James Shorey? Questions on the opportunity zone deals?
So again, those are completely different animals because they have restrictions in order to comply with the different requirements. So, didn't want to get into that in this sort of conversation, but it adds a whole nother level of complexity to the shape of these transactions and these agreements. So
I'll ask a question, since I'm an educator, about what do you think is the best training that young lawyers can have if they are interested in the type of practice you have, or what should they concentrate on so that they can enjoy a practice as challenging and diverse as yours is?
Well, like any expertise in sophisticated corporate finance transactions like these, there's no getting around the experience. You have to put in the time. You have to get a number of deals under your belt. You have to read and reread 100-page documents, forcing yourself to understand every word, forcing yourself to understand, why is this provision in here? Why does it matter? To understand the way these documents work, to understand the way these transactions are structured. That's on the legal side. But almost more important than that is you need to do enough of these deals and have enough experience to understand what's market. If you don't know what's market, you're likely going to get presented with a very one-sided document by the fund member, by the private equity fund. And they're not trying to screw you. They're just trying to get the best deal that they can get. And you may not even know where there are opportunities to move them off of the 5-yard line and get them closer to the 50-yard line. That takes experience. That takes, staying on top of trends, because these things, like everything else, these things evolve. You've got private equity funds that are competing for deals, and they're not going to do well in that competitive landscape if they engender a reputation of not being fair, of not being easy to negotiate with. So they're motivated to be good partners. They're motivated to be fair. But if you don't know what you're doing, you don't know where those opportunities are. You may find yourself agreeing to things that, frankly, you may not have had to agree to if you just would have known where to push and how to push, and where your leverage is and where your leverage isn't. And much like in the M&A world, it highlights a very important point. Your best opportunity to maximize your deal, your joint venture, is at the letter of intent stage. That is where you negotiate and you get what's important to you into the letter of intent. If you poo-poo the letter of intent and you wait for definitive documents, you've missed your best chance, because your leverage will never be greater than it is before you sign the letter of intent. Just like an M&A deal. Once you sign the letter of intent as a seller, your leverage goes down. The deal's only getting worse for you. It's never getting better.
That's interesting. So we have another question in the chat. What is the, oh, that's for me, the activity code? I'm sorry, I will put that in for CLE. So I guess if no one else has a question, we have a moment. I would ask, what are some of the most contentious issues that you face? Because you talked about getting to the 50-yard line and how you get there by being aware of what other deals are, market trends. But what are the issues that really cause you to stay up at night or worry, or anyway? So
the biggest ones are ones that we talked about. Your fund member partner has all this power, And they can wield that power in a friendly way, or they can wield that power in an unfriendly way. They could cause the company to do things that might trigger your guarantee. They could cause the company to be sloppy with their environmental matters, much against your better judgment. So the real sticky wickets are controlling how and when you can get kicked out of the deal, and controlling your exposure on the guarantee side, on the credit support side, when you don't have full control. You're not really driving the bus, but you're the one responsible if the bus hits anything. Those are the rubs. And that comes back to my very first comment, which is you can do the best job you can in getting these documents right. But at the end of the day, you have to be with a partner that you trust. And the first deal is the hardest. And after that, they all get easier. And once you start establishing a track record with each other, a rapport, a manner of dealing with each other, a level of trust, it becomes a lot easier. The words on paper mean less. The personalities mean more, which comes to another good point. On the operator side, the fund member pretty much knows who he's dealing with. He's dealing with the operator. On the operator side, you may be dealing with Jim Smith as the managing director of ABC Fund. But a year later, Jim Smith may have left. He may have gone to another fund. Now you've got Lisa Johnson. Completely different personality. So you gotta, you have to have an institutional level of trust, because the people on the fund side are likely to change, clearly more likely than on the operator side. So you just don't know who you may wake up with the next day, frankly.
So we have one more question in the chat. And Todd Roby, do you want to ask your question yourself, or do you want me to ask it? Let me see. All right, there we go. So the question, this is our last question, Dominic. From the sponsor's perspective, it sounds like there are many challenging provisions that you have to face in the agreements. Among these various provisions that you highlighted, have you seen any changes in any of them, tightening or perhaps loosening during these 2020 market changes? And that will be our last question.
Well, I think if anything, it's all a function of supply and demand, right? So pre-COVID, private equity funds, all this capital, they're starving for deals. They're looking for good operators. They're going to be more willing to sort of bend their normal documentation. They may be more willing to take a more accommodating stance with you. Now, in COVID, it really depends on what asset class you're talking about, right? I mean, there clearly is no demand right now other than opportunistic people looking for retail, right? Even office is challenged right now. On the contrary, industrial is doing much better relative to the other asset classes because they haven't been as affected. So generally speaking, similar to corporate private equity, you've got a lot of money on the sidelines that needs to be deployed. There's not enough supply of deals. And when that's the dynamic, as a sponsor with a potential good deal, you've got much more leverage to move the needle more in your favor than not. So in this COVID world, the answer really depends on what asset class you're talking about.
Well, thank you for that final remark. And I just wanted to thank you so much for sharing your expertise. And we learned so much today. We will, in the chat now, place the CLE number, which I will do right at the moment. And then we will probably have to end our session for today. And I'm so glad everybody was able to join us. And it's wonderful to see you again remotely.
Likewise.
Great. Thank you again. It was wonderful.
Thank you. Thanks for having me.
So at this point, I think I'll end the meeting. Because we're at 5:30. I hope everyone stays healthy